Hello everyone. Today I'm going to discuss with you the third very sources of international law, and that is your general principles of law which are recognized by the civilized states. And para 1, clause C of Article 38 of the Statute of International Court of Justice, it lists the general principles of law recognized by civilized states as the third source of international law. And the in the modern period, it has become an important source. It constitutes an important landmark in the history of international law, inasmuch as the state parties to the statute and expressly recognize the existence of third source of international law independent of custom or treaty. This source helps international law to adapt itself in accordance with the changing times and circumstances. The general principles of law, and these are those principles which have got recognition from all the states and by all the legal systems of the world. The general principles of law, these are based on justice and equity. They include the basic principles of law which are indisputable. They provide a mechanism to address international issues not already subject either to treaty provisions or to binding customary rules. So, why these general principles of law are included? The main reason why this source is included in International Court of Justice is because a situation may arise when there is absence of law relating exactly to the point. International law has no method of legislating to provide rules to regulate new situation. Neither it follows principles of past precedents. Hence, the provision of general principle was established as a source of law to fill the gap and solve the problem of non-liquid, that is a situation when the court refuses to settle disputes on the ground that rules are not available. Now see that like this general principles, uh, one of the scholar like John Glenn, a renowned author of international law, he pointed out that two views are prevalent about the phrase general principles of law recognized by civilized nation. According to one view, the phrase includes such principles such as both sides of a dispute should be given a fair hearing and no one can sit in the judgment in his own case, which are found in domestic jurisprudence and can be applied to international legal questions. The other view regards the phrase as linked to natural law as interpreted during the recent centuries in the Western world. According to this view, general principles of law recognized by civilized nations have emerged as the result of the transformation of broad universal principles of law applicable to all the mankind into specific rules of international. So, as I have told you, that by general principles of law recognized by civilized states, we mean those principles which have been recognized by almost all the states. Owing to the gaps of Indian international law, there is a gap in international law, and it was felt that the competence of court it could not be confined to making judgments according to positive international law, that is, according to custom and conventions. But on the other hand, it was not designed to give free rein to the law-making activity of the court, and the court had to content itself with applying principles of law which could be established as common to the municipal law of all civilized nations and were therefore positive law, though not positive international law. There are various principles, there are various cases like in which involve the general principles of law. The Permanent Court of International Justice in Mosul boundary case, it applied the principle of natural justice that no one can be judged in his own suit. And there are numerous other cases too. Just as, for example, in R versus Kane, in this case, the court ruled that international law is based on justice, equity, and conscience, which has been accepted by long practice of states. In United States versus Cooner, in this case, Justice Story of United States of America, it ruled that international law should be based on the general principle of law recognized by civilized states. He was giving decision relating to abolition of system of slavery. In the case of diversion of water from use case, the Permanent Court of International Justice, it applied res judicata and estoppel. So there are numerous cases in which certain general principles were enunciated with the time. Now, the fourth very like important source of international law is the judicial decisions, or decisions of judicial or arbitral tribunals and juristic works. It is a subsidiary source, and Article 38 it recognizes a judicial decisions as a subsidiary source of international law, but not an actual source. Even Article 59 of the Statute of the ICJ, it provides that the decision of the court have no binding force except between the parties in respect of that particular case. And while the doctrine of precedent it does not exist in international law, one still finds that states in disputes and textbook writer court judgments of the Permanent Court and ICJ as authoritative decisions. So you see that in the modern period, the International Court of Justice is the main international tribunal, judicial tribunal, and it was established as a successor of the Permanent Court of International Justice. It may, however, be noted that the decision of the ICJ it does not create a binding general rule of international law, as stated in Article 59. Earlier decisions of the court are not binding on the court itself, and the court is free to deviate from its earlier decisions. However, ordinarily, the court does not deviate from its earlier decisions, and it changes its earlier decisions in only in very, special circumstances. Thus, while in principle it does not follow the doctrine of precedent, in practice it ordinarily follows it. So, you see that according to Article 38, Clause 1, Clause D, subject to the provision of Article 59, the judicial decisions are subsidiary means for the determination of the rules of law. And the judicial decisions, unlike the custom and treaties, they are not the direct sources, but they are the subsidiary and the indirect sources of international law. And the state judicial decisions may also become the rules of international law in two ways. Then, the state judicial decisions are treated as when they are treated as weighty precedents, and the decision of the state courts may become the customary rule of international law in the same way as the court's customs are developed. So, so you see that this is the fourth very important source of international law. That is, their judicial decisions and also the juristic works. The juristic works it cannot be treated as an independent source of international law. Yet the view of the jurists may help in the development of law. They are not the direct sources, but they sometimes become instrumental in the development of the international custom. So, the importance of the work of the jurist, they have been stressed by Justice Gray in Paquet Habana. So you see that the work of the jurist is also play an important source of international law. So these are certain important sources of international law. The fifth one, you can read the writings of the publicists has already been discussed with you. There are certain other sources also which are considered to be an important source of international law, like draft conventions, ex equo et bono, equity and justice, General Assembly resolutions, consideration of human, international committee, legally binding resolution of the international organizations, state practices, soft laws. So you see these are the other sources of international law. like uh, like international like ex equo bono. What is the meaning of it? Article 38, Clause 2 of the World Statute, it qualifies by providing the ex equo bono, and so this Article 38, Clause 2, it provides this as ex equo et bono. And apart from this, various other sources like international committee. That means what? The mutual relations of the nations. These are based on the principle of committee. For example, in other words, you can say when a state behaves in a particular way with other states, the latter have also to behave in the same way. So, according to Professor Oppenheim, International Committee has helped in the development of international law. Then, even equity and justice, it is also very important. Like it can be regarded as another source of international law. In various cases, it was held, just as in the Barcelona traction case, it was held that equity is one of the important sources of international law, and where it talks about the equity, even in the North Sea continental shelf cases, the International Court observed that like whatever the legal reasoning of a court of justice, its decisions must definitely be just, and therefore in that sense it should be equitable too. Reason also play a very important source of information, a source of international law. Even the resolutions and declarations of the General Assembly of the UN is also considered to be a source of the universal international law. And there is a great controversy, in regard to the legal significance of the resolutions and declarations of the General Assembly of the UN. Some jurists, they are of the view that they are only of political significance and have no legal importance. On the other hand, some jurists hold the view that under certain circumstances they may have legal implications, and some of them may even have the binding effect. So you see that even the resolutions and declarations of the General Assembly of the UN are considered to be the source of universal international law. And the decision, taken by the General Assembly, it proves to be helpful in the development of international law. These decisions, they are in the form of recommendations and resolutions, and some of them are never implemented. Yet they are helpful in the agreement between the states and contribute in preparing the necessary environment for the development of the rules of international law. So you see that the resolutions and declarations of the General Assembly, it has capacity to become the sources of universal international law. So you see that these are the four important sources of international law as such, that is the international conventions or treaties, the international customs, the general principles of law recognized by the civilized states, the judicial decisions and the juristic opinions as the subsidiary means for the determination of the rules of law. And apart from this, this ex equo et bono, the equity and justice, the resolutions and declarations of the General Assembly, the International Committee, the state practices, all comprises the sources of international law. So, in this manner, like you can find like these sources to be very pivotal in dealing with the international law as a whole. And this sources also comprises of the sources of international migration law too. As we know that, the international migration law, it is also a subset of public international law. Moreover, you see, like there is a lot of things which are used regarding the ex equate bono. The question which arises, like, can ICJ give a decision on the grounds of fairness and justice or not? Or can ICJ give a and this term, the ex equate bono, it is often used in international law when a matter is to be decided according to the principles of equity rather than by points of law. And this Article 38, Clause 2 of the Statute of the International Court of Justice, it provides that the court may decide cases ex equo et bono if the parties agree thereto. For example, in 1984, the ICJ decided a case using equitable criteria in creating a boundary in the Gulf of Maine for Canada. So you see, these are the various like important sources of international law, and also the importance of this like sources, because it helps in developing the international law as a whole too. And while dealing, so before understanding the sources of international migration law, we have to learn, we have to see and understand and have a clear understanding about what are the different sources like of the international law as a whole. And there are numerous case laws also where the different sources of international law has been upheld. And for most important, you see, the sources can be regarded to the formal and the material sources too. And accordingly, there has been a distinction, categorization of the sources also. And this international conventions, it is also plays a pivotal role or pivotal source in the international migration law too. So this is a brief discussion on the various sources of international law as a whole. I'll be dealing with the in the next video lecture regarding the sources of the international migration law. And also you see that you have to go through a lot of conventions and treaties, because it is a primary source of international law, and it is very we have to go through it like properly, so that you will have a brief understanding about the different sources of international migration law. And this international treaties plays a very important role while dealing with the every kind of issues, because whenever the problem goes before the international court of justice, like you or tribunals, you see these treaties play a very important role, because whenever there should be whenever the question of resolving an issue comes, so the next question come up, whether there is a treaty between the two states or not, whether they are bound by it or not, whether there is an obligation upon the states to follow that or not. So everything has to be taken into consideration while dealing with the international law. So these are the important source of international law. Moreover, you see that apart from these discussions, you see that the customs also is a very important source of international law. And so is the case in case of the international migration law too. So this customs, it's also very play a very important role. And you also have to see whether how these customs have been developed, because there are various like necessary formalities to be followed to be developed, to be regarded the custom as a source of the international law, as the duration, as it should be uniform and consistent. There should be acceptance by the states too. So you have to see whether this international custom has developed in that manner or not, whether it comply with that requirements or not. And moreover, you have to go through numerous cases where there are various principles of law recognized by the civilized nations, and which has played a very important role. Some of the cases, like in the in the Chorzo factory case, in that case, the Permanent Court of International Justice, it applied the principles of res judicata, and also held that one who violates the rule is liable to make a reparation. And there are numerous other cases like Barcelona traction case, preliminary obligation. In this case, the ICJ, it applied the principle of estoppel. Moreover, in the frontier dispute case, like in 1983, Burkina Faso and Mali entered into an agreement to refer the frontier dispute to the ICJ. And during the agreements, Mali contended that form of equity ought to be kept in mind, which is inseparable part of the interpretation of international law. Moreover, you see, apart from these sources, the decisions or determinations of the organs of the international institutions, it also plays an important source of international law. Like, before the establishment of the League of Nations, international customs and conventions were recognized as the main source of international law. And apart from the juristic works in the decision of judicial and arbitral tribunals were regarded as a subsidiary means. And the Statute of Permanent Court of International Justice under Article 38, it incorporated these sources and also introduced one new source, namely the general principles of law recognized by civilized nations. So Article 38, however, did not at all mention the decisions or determination of organs of international institution as a source of law. Moreover, you see like that the evolution of the international organization, it represents a significant stage in the history and the development of international law. And this international organization, in the wider sense, it is the process of organizing complexity of international relations. And in a narrow sense, it is an international institution based on multilateral international agreement entered into by the sovereign states. So you see that like the decisions or determinations of the organize or organs of the international institutions also, they also are important while dealing with the the sources of international law. So this is a very discussion on the sources of international law as a whole.